Hello everyone, morning. Today let's talk about the very recent federal court ruling on Malaysian skinny contempt of court case. Let's go over the news article before I highlight two issues that I find very concerning about the judgment. All right, so let's go to the case. Let me share the screen. Okay. Federal court finds Malaysian Kini guilty of contempt over readers' comments and imposes 164K fine. Independent Malaysian news site Malaysian Kini has been found guilty of contempt and fined 500,000 ringgit Malaysia. That is about this number, by the country's highest court over comments posted on its website by readers, not written by themselves, but comments by readers. In a 6-1 judgment by a 7-member panel, the federal court on Friday ruled that Malaysia Kini should be held in contempt over the comments on an article published on June 9, 2020. The article was about the reopening of Malaysian courts following a national lockdown last year, so it's related to COVID. The court, however, did not find Malaysian Kini's editor-in-chief Stephen Gunn, who was named by prosecutors as the second defendant, to be guilty of contempt. Malaysia's AG initiated the contempt proceedings against Malaysia Kini over 5 comments posted on the article. The comments had, according to the AG, implied that the judiciary committed wrongdoings, was corrupt, and lacked integrity. In reading the summary judgment, Federal Court Judge Rohana Yusof acknowledged concerns that the case and its verdict might have a chilling impact on press freedom. However, Tan Sri Rohana stressed that contempt of court was not allowed under the law. And the law does not tolerate contempt of court as it undermines the system of justice. So that's the reasoning, the judge said, urging Malaysians to use their discretion when posting on the internet. Otherwise, you'll be slapped with the contempt of court criminal charge. The judge also said that Malaysia Kini could have deleted or moderated inappropriate comments, as it had an impressive editorial structure and the comments should not have gone unnoticed by the team. So there was a moderation system, and the judge said that the moderation system should be enough to detect and moderate and delete the relevant comments, right? The court's decision has immediately raised concerns regarding media freedom in Malaysia, with foreign missions, lawyers, politicians expressing their support for the online news site. In a joint statement on Friday, the British High Commissioner to Malaysia, Mr. Charles Hay, and acting Canadian High Commissioner Esther Vannes said they were concerned by the court's verdict. So this case ruling doesn't sit comfortably with the common law system as exercised by the UK and Canada. People must be allowed to debate and discuss issues freely, they said. Lawyer Lim Wei Jiet, meanwhile, said that the court ruling is bound to have chilling consequences on media freedom in Malaysia. Mr. Lim pointed out that the ruling might lead to other Malaysian news portals disabling their comment section. Well, that's a real possible consequence. That's very concerning. This decision has opened a Pandora's box, and it ain't pretty, he said on his Twitter handle. A public campaign to raise funds to help the 21-year-old company pay the fine has also taken off on social media, leading to Malaysia Kini being one of the top trending topics on Twitter on Friday. Malaysia Kini said later Friday that it has managed to raise at least 552,321. Wow, I think that exceeds the fine right? So people are supporting this. That's very good. Mr. Gan had described the fine as a body blow and said that it might be an attempt to shut down Malaysia Kini. For those of you who are not aware, Malaysia Kini has been the anti-establishment news site for a very, very long time. Whether you agree or disagree with their views, that's not relevant, right? The government's move to pursue the contempt proceedings had previously raised alarm among media watchdogs in Malaysia, with the Center for Independent Journalism previously labeling the court action as disproportionate and a serious threat to freedom of expression. Malaysia Kini had previously argued in court that Malaysian laws did not require online news sites to pre-moderate comments on its website. Malaysia Kini, which was founded in 1991, is one of Malaysia's earliest online news outlets and is among the few news organizations that retains comment section on its website. So other mainstream websites not doing that, right? Just Malaysia Kini. Very brave, I would say. So that's the news. So let's now look at the judgment. I won't read all of the judgment because I know people may not be interested in the long judgment. Instead, I'll just pick 2 paragraphs from the judgment and then raise my own opinions about paragraphs, all right? So let's first look at one of the core issues related to the intent. So in order to commit a crime, in most of the cases, you must have an intention, right? That's common sense. So in this case, the intent became an issue because clearly the Malaysia Kini and its editors and stuff, they didn't write a comment. They weren't even aware of the comment until they were notified of it. So was there an intent to be in contempt of court? The ruling says yes. Why? Let's look at the judgment, paragraph 8. So he cites a case, Imeno Yao Teku and public prosecutor, is a Malaysian case. So Richard Melanjam, FCJ, in this case, held that proof of intention or knowledge could generally be inferred from proved facts and circumstances. So you do not actually have to have genuine intent in your mind because it can be inferred from circumstances, right? It is difficult to do so by other means unless there is a clear admission by the person himself, right? The principle of law is that to determine knowledge, the court is concerned with reasonable inferences to be drawn from a concrete situation disclosed in the evidence and how it affects the particular person whose knowledge is an issue. So this case basically says that you can deny intention, but we can infer from the facts. And through the following paragraphs, they indeed did infer intention. That's why they found them guilty of contempt. So let's talk about this case. First of all, what's this case about? And let's go to the case. This is the case, the case they cited, the Imeno Yao Teku, all right? So this is the case. This is a 2007-6 case, right? In the federal court, also highest court, right? Imeno Yao Teku and this PP. So what's that case about? Oh, this case is not about contempt of court. This case is about trafficking in heroin. This case about trafficking in heroin is not about the contempt of court. And if anybody of you is fairly familiar with the Malaysian court system, you know that trafficking in heroin can lead to death penalty. The contempt of court, in this case, is fine. So my question is, why is the court using a drug trafficking case law to support their judgment instead of the many contempt of court rulings? This is the first issue. I don't get that at all. Is it because the contempt of court rulings before had a more stringent requirements to determine intent? So they try to use this drug trafficking case to kind of like, oh, because there's this judgment before, so we are going to use this, right? Is that the reason? I don't know. I think legal professionals should come out and really discuss on this, and I really appreciate if any lawyers can shed light on this matter, right? This is the first issue I have. The second issue I have is with paragraph 3. So, but before looking at paragraph 3, let's take some time to just look at the comments themselves, all right? So what did the comments actually say? So first, from Ayah Punya Kata, all right? The high courts are already acquitting criminals without any trial. The country has gone to the dogs, all right? Grade year 0609, Kangaroo Court fully operational. Musa Aman 43 charges fully acquitted. Where is law and order in this country? Law of the jungle, better to defund the judiciary, right? Second command. Third command, legit. This judge is a shameless joker. The judges are out of control and the judicial system is completely broken. The crooks are being let out one by one in an expeditious manner and will run while looting the country back again. This chief judge is talking about opening of the court. COVID-19 slumber car. All right. Fourth command by semua boleh, bodoh pun boleh. All right. Hey, Chief Justice Tengku Maimun Tuan Mat, berapa juta sudah sapu? So how many cases have you like swept off? So 46 corruption cases just acquitted, right? So you don't know shame. Are you not afraid of God? In Islam, God's name is Allah, right? So are you not afraid of hell, neraka? Are you not afraid of that as well? Furthermore, bayar balik sedikit wang sapu lepas juga. So another like charges, just acquit as well. What justice is this? Is it about defrauding the people, rakyat? Sama-sama sapu wang rakyat. So are you part of the, you know? So the fifth command, the victim, the judiciary in Bolaland is a laughingstock. All right. So we now know what the comments are like. So let's talk about paragraph 3. Malaysia Kini admitted that the comments are indeed offensive, inappropriate, disrespectful, and contemptuous, and regretted the publication of them. Notwithstanding the admission, both Malaysia Kini and Stephen Gunn maintained that they both play no role in publishing them. So they admitted that the comments are offensive, inappropriate, disrespectful, and contemptuous, right? Really? Are the comments really offensive? really inappropriate, really disrespectful, really contemptuous, really. For this, we must know that when we talk about the contempt of court in an ideal situation, I'm not saying that the Malaysian law is this. I'm talking about the contempt of court as an ideal. When we talk about contempt of court, we are not talking about some physical entities, the place, the court as a place, or the court as the legal, the persons in the legal system. No, contempt of court is not about that. Contempt of court is about you are in contempt of the ideals that the court subjected itself to. So what is that? For example, legal process, due process, due diligence. Well, what else? Rule of law. So things like that, the ideals like that. So when, let's say you are slandering the judge and stuff like that, you are in contempt of court. You are in contempt of court not because you slandered the judge as a person. You're in contempt of court because you slandered the judge as the representative of the legal system. So for this, I have one academic article to share with you, and that's the law of contempt of court in Malaysia, considering reforms. And this is by this, oh my God, A. Vijaya Lakshmi Venugopal and Kamal Halili Hassan. So two academics, one PhD graduate in the Faculty of Law, University Kebangsaan Malaysia, and another also from the Faculty of Law, UKM as well. What did they say? What did they say about the current status of the law and the contempt of court? So I'll read a few paragraphs, one excerpt, and then you can decide for yourself, right? So this part, let me enlarge it a little bit. Okay. Judges' role as guardians of the law, justice, and the public's confidence in the integrity of the legal system. The formal legal system is a staple feature of most modern societies. The system in itself is merely a complex series of procedures and practices. The real structure and prestige of the legal system is not just in its buildings or offices, but primarily in its personnel. Among all its personnel, the office that probably is the most visible embodiment of the legal system for the public is the judge. A judge is a visible representation of the legal system. Benjamin Whitcomb wrote that a judge is the law speaking. It's a very respected professional, right? Therefore, when the judge acts in his professional role, his conduct reflects on the legal system. Philo wrote that a judge should bear in mind that when he or she tries a case, he or she is also on trial. So when the judge judges, he is also judged by the public at the same time. Every time a court judges, a judge judges any case, right? That's how respected the profession of the judge is, right? Let's read on. Judges are bound by the Judges Code of Ethics 1994, which apply to their conduct throughout their period of service. Apart from other specific ethical duties, Section 3, Sub 1, Sub D of the Judges Code of Ethics 1994 imposes an obligation on the judges not to conduct themselves dishonestly or in such a manner which brings the judiciary into disrepute or discredit. So not only are we, the general public, judged whenever a judge judges the case, the law itself, their code of ethics itself, also judges them, right? This is an extremely broad duty. There's a duty to judge doing their job. The breach of duty of any of these ethical obligations can subject the judge, even of the federal court, to the risk of being removed from office. So this is a legal duty that the judge has. The judge is not, as a person, is not the ideal. The judge as the legal profession is the ideal, and we should respect that, right? A great deal is expected of a judge, perhaps too much. C.K.G. Philae in 1985 wrote that a judicial officer's life is not easy, as too much is expected of the judicial officer. C.K.G. Philae went on to quote Professor Jeffers' comments that a judge is expected to pronounce the law, be a prophet, have the wisdom of Solomon. Solomon is a biblical king, by the way. The moral vision of Isaiah. Isaiah is also a biblical prophet. The analytic power of Socrates, the great philosopher. Intellectual creativity of Aristotle, also the great Greek philosopher. The humanity of Lincoln, or the founding father of America, and the impartiality of the Almighty God himself, right? That is how respected the judge as a legal profession is. It is admitted that these are extremely high ideals for anyone to measure up to, right? Whether such expectations are fair or not, judges too are subject to scrutiny regarding their professional behavior. Judges' decisions and commands are often reported and highlighted by the media. Therefore, judicial remarks can affect the public's regard and respect for the legal system. So we respect the legal system by judging the judge. Since the law and contempt of court is intended to uphold the integrity of the legal system, judges exercising this power should be all the more concerned that the decisions and commands in such cases do not invite public ridicule. So it is actually the judge, their job, not to make the public concerned about their integrity. The Right Honorable the Lord Mackay of Clashford, I guess it's a UK judge, not sure, wrote that most of the cases heard are in open court and judgments are given publicly. As such, each judge is often before the public. There is thus plenty of material in the public domain which can be used to evaluate judicial performance. Evaluation of judicial performance is a very normal discourse by the public. It's a very noble one indeed, I think. Every judge, let's read on. Every judge has a heavy responsibility to uphold justice. No matter who brings a case before the court, no matter what issues are involved, no matter how many people are affected by the dispute, each litigant comes to court asking for justice. The judge faces the that's a typo, by the way, unevitable task of, unenviable. I think it's unenviable. I'm not sure. My English is really sucks. The unenviable task of sorting through countless arguments, principles, and ideas to arrive at what is hoped is the fairest solution for the parties involved and as a precedent for future cases. Hastie in 1973 comments that judges understand and are professionally dedicated to the rule of law and effective functioning of judges as authoritative representatives of the legal orders. They are not judges in themselves. They are representative of some higher ideals: justice, fairness, rule of law, you name it. The abstract idea of justice, let's read on, may be clear. However, deciding how justice should apply in the facts of a particular case is far from clear. M.A. Hafiz Siddiqui, I think, in 1970 wrote that judges are guardians of legality. The judiciary undertakes to solve complicated problems, which, like a spider's web, if one strand is adjusted, this can result in a complex pattern of adjustments running through the whole web. So the judge's job is very important. That is why the general public is so concerned about their judgments. A very healthy skepticism, I would say. Has he observed that a judiciary is required in any society that has progressed to the stage of settling disputes by peaceful decisions rather than combats between the disputants? The courts do not serve to run society, but rather to prevent society from running wild. It suggested that judges play an increasingly significant role in upholding justice for society as more and more cases, blah, 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 same. Okay, contempt of court stems from the need to uphold the integrity of the administration of justice, right? That's why there's this criminal offense in the first place. Tremblay, 1991, wrote that contempt of court is intended to ensure the integrity of the judicial system and protect the rights of parties who are on trial. It is submitted that this is a very important function of this law, and one that has a fragile balance to achieve. Integrity is subject to conflicting interpretations from the parties, in each case to others commenting on cases. It is the judge's heavy responsibility to try and uphold the integrity of the legal system to the best of his or her opinion of what this requires, right? Let's read on. I'm sorry, man. It's long, but it's gonna end soon, all right? Hang with me, all right? Just 3 more paragraphs. I know some of you already quit, but hang with me, all right? Right? Let's read on. A legal system, to a certain extent, depends on its public image to be useful. If people believe that the legal system is corrupt and partial, many would not seek its protection, rendering the legal system futile. The law on contempt of court empowers judges to punish discourtesy and disrespect of the legal system by anyone, be they lawyers or not, before the court of law. If people are dissatisfied with the judgments of particular judges, they should pursue appropriate means and channels of expressing their criticism, not by casting broad and unfair slurs indiscriminately. The legal system must be useful, but also believed to be so. Milton, 1970, wrote that the administration of justice requires not only that there should be a fair and impartial determination of proceedings, but also that the parties to those proceedings believe that they have received such an adjudication of their interest. Fernando in 2005 also clarifies that contempt of court exists to protect the public rather than the glorification of the judiciary. So the contempt of court, this criminal charge, is there to protect the public, not to glorify the judiciary or anyone within them, right? Even the Supreme Court in AG and Arthur Lee Meng Kwang, is a Malaysian case, by the way, noted the need to protect the dignity and integrity of the superior courts in the interest of maintaining public confidence in the judiciary. It is admitted that this need extends not only to the superior courts, but also to all courts. Tilford wrote that the court's moral authority comes from the public. So the court's moral authority comes from the public. And the courts could not properly function without this support. A common rationale for the law on contempt of court is to maintain the public's confidence in the legal system. Chinnock and Payton in 2003 explained this further. The right of public interest served by contempt of court is the party's right to a fair trial before a court of law. This is fundamental in a free society governed by a civilized system of justice. A basic tenet of such a society and critical to the assurance of public faith in the rule of law and the proper administration of justice. The law of contempt of court supports this by providing punishing misbehavior that undermines a fair trial, resulting in disrespect for the rule of law and causing a lack of public confidence in the administration of justice. There will always be those who criticize the legal system. To some extent, this is inevitable, with nearly every trial resulting in at least one party losing the case. This is inevitable, guys. It is just the matter, the matter of whether you put it online or not. This discontent or dissatisfaction with the court's proceeding will persist, perhaps forever, as long as there's a legal system in place. Because if you know a little bit about the legal system, in nearly every case, there's a win and there's a loss. Of course, in some cases, they are like settlements, but in the majority of the cases, it will be a win. One party winning and one party losing. So there'll always be dissatisfaction, right? Hastie in 1973 wrote that adversary litigation involving government or private individuals always has two sides. The sides are always there, just that now you are not, I think, you are not allowed to voice out your dissatisfactions anymore, right? Because of this ruling. I'm afraid. I'm not sure if this is the case, but I'm afraid this is going towards this direction, which is very, very concerning. As such, the courts will decide against half of those who contest lawsuits. It's common sense. Inevitably, there will be losers and their supporters. Common sense, who may express their dissatisfaction with the court's decision not in their favor. Common sense. Hastie in 1973 observed that it is often more popular to condemn the courts rather than to support them. Well, that's his belief. However, Hastie warned that widespread and continued denunciations and manifestations of the lack of confidence in the judiciary can have catastrophic consequences for the functioning of society. It is submitted that the courts have the power to lawfully enforce justice. If people do not use this method and seek their own redress against those who have wronged them, it can result in further unlawful and unfair behavior. So this is the other side of the coin. The federal court majority rulings, their side, right? So there may be, it is also true that there may be widespread and continued denunciation and manifestations of the lack of confidence in the judiciary, and it can have catastrophic consequences, right? So now with all this long ass script in mind, let's look back at the comments, see what they are about, right? First, let's look back, right? Ayah punya kata. The high courts are already acquitting criminals without any trial. The country has gone to the dogs. Let me interpret this statement, all right? So the high court, so the country has gone. So before that, it's good, right? And the high courts are acquitting criminals without trial. So what this person is saying is that there is a supposed trial that is supposed to take place, and the high courts are not doing that, right? So in other words, this person actually advocates, not only advocates, he or she respects the higher ideals that the judges themselves are subject to. He or she is just saying that the judges are not doing their job, right? How's this contempt of court? How's this disrespecting the legal system as an ideal, right? Second comment. Kangaroo courts fully operational. So, fully acquitted. Where is law and order in this country? Law of the jungle? Better to defund the judiciary, right? This is more clear. This comment is more clear. He's asking, where's the law and order in this country? He's not only is he respecting, but he is actively advocating for the higher ideals as well, right? And he accuses the court as kangaroo court. So there is a court that is not kangaroo court that is actually good. That's what he's saying. And that somehow becomes contempt of court, right? Third one. This judge is a shameless joker. The judges are out of control and the judicial system is completely broken. The crooks are being let out one by one in an expectation manner and will run while urging the country back again. This judge is talking about opening of the court, COVID-19. Okay, so let's look at this. The judges are out of control. There's a control mechanism that should take place. The higher ideals of justice, rule of law, and fairness. But the judges are out of control. That's what he's saying. And the judicial system is broken. That means the judicial system itself is good, just that it is now broken. So we have to fix it so that it becomes a good judicial system again. How's that disrespecting the court? How's that disrespecting the court? I do not know. If you can shed light on this matter, comment down below. I stand corrected, man. But how's this contempt of court? I don't understand, right? So this fourth comment. Hey, Chief Justice Tengku Maimun Tuan, blah blah blah, blah 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 blah. So are you not ashamed? Are you not afraid of God Almighty? Are you not afraid of hell? Where's justice? Again, this person, this commentator, oh my God, my English sucks. This person who commented is seeking for the higher ideal, justice, the higher ideal. So, right, and he talks about fearing God. And if you remember, oh my God, if you remember, just now in that academic article, right? Okay, yes, so the court ideals, let me read it to you. Let me read it to you again, right? What should the court, what should the judges strive to become? Should strive to become to pronounce the law, be a prophet, have the wisdom of Solomon, the moral vision of Isaiah, the analytic power of Socrates, the intellectual creativity of Aristotle, the humanity of Lincoln, and the impartiality of the Almighty God. That's what the comment is talking about, guys. Although this person may not have read the law, may not have read this academic article, but his conscience, his or her conscience is calling for the higher ideal. In his case, the Islamic God, Allah, right? How's that contempt of court? Wow, that's a good question, I think. Right, the final one. The judiciary in borderland is a laughing stock, right? Again, there's a laughing stock judiciary. There's a good judiciary that is not a laughing stock, right? You can interpret it. I'm not sure what his, I'm not saying what he's saying is that, but it can be interpreted as that. And know that contempt of court is a criminal charge, right? So you must prove beyond reasonable doubt that what he's saying is actually a contempt of court. But now you can actually interpret the statement as, oh, there's a laughing stock judiciary. There's also the not laughing stock judiciary. You can interpret it that way. It's not clear. So all of these statements that appeal to the higher ideals, be it justice, fairness, rule of law, impartiality, or even God Almighty Himself, right? All these comments now, according to the federal court, are contempt of court. Well, that's something to think about, ain't it? That's all for today. Thank you. Goodbye. End this shit.